I was going to move on to Sten and Headley, which further explained the addition to the land, but I think we've established that, have we?
That point is made in law.
Yeah.
I think we all appreciate that land is capable of being transferred by a DMC,
Yeah.
unless you're about to argue otherwise.
Nope, that's fine. The Woodard and Woodard case I would like to explore a bit further, if that's okay. Before doing so, I would bring to the attention of the court that my learned friends have cited a case of Woodward and Woodward, 1992, which doesn't
This
exist.
has been noted by the court. Thank you very much.
It's
Thank you.
Woodard, W-O-D-A-R-D versus Woodard.
That's correct.
I've got the all-in-all version.
Yeah. There was a Woodward and Woodward in 1957, but wouldn't relate to the instant case.
Okay.
I want a clarification on this, not as it may seem to bring attention to their oversight, but rather to invite them to concede that the case of Woodard and Woodard is further proof of, amongst other things, the need to be in contemplation of death, as well as to transfer the property. It is debated somewhat throughout the judgment of Woodard and Woodard whether the late father parted the car as a donation mortis causa. However, the key facts were in consideration when reaching the judgment of whether there was, and we've really got to look at it and see the obvious thing to jump off the page. The father was in hospital, he was dying of leukemia, he knew he was dying of leukemia. The son was in possession of the car. Prior to the father's demise on one of his earlier visits to the hospital, he was witness to saying that he gave Barry the keys that he'd given the car. However, he didn't die on that occasion, and he took back ownership of the car, which is exactly the requirements of a donatio mortis causa. So it's quite a stark contrast to the instant case in terms of facts and whether or not there was contemplation of death and whether or not there had been that second requirement of the rules. Well, Lord, I probably could go on with Woodard and Woodard making quite a bit of comparable argument. There is actually so much that we compare, but again, I don't think there's much need to take up the time. So that does conclude my submissions, and I welcome any questions you may have.
I have one on Woodard. I mean, I did look at this case pretty carefully. My understanding is that you say there are significant differences. I don't see that. I see quite significant similarities. In fact, if anything, one of the features of Woodard leaps off the page, which is that there was no evidence of intention. You know, this was a temporary loan of a car. There was no expressed intention of transfer, nothing of the like. Compare and contrast that with the facts of the current appeal, where there is an expressed intention. In fact, the problems arise later down the timeline. So on the evidence, it said there had been no valid outright gift, and that was the conclusion of Woodard. But there are other features which would lead the court to think, well, again, I come back to this point which we were looking at earlier, that all the steps that have been taken were taken. What was missing was some of the formalities at the conclusion of the, that would have rendered the transfer. I don't necessarily go with the point that she could have taken further steps to complete her intention, because I think the intention was already settled. But the Woodard case isn't as clear-cut as I think you are making out, with huge respect, Mr. Miller. I'd just like you to revisit that point briefly for us. Just go over again why Woodard is so distinctive.
Well, I thank your Lordship for the opportunity to explore it further. First of all, I mean, at the offset, we have a relationship that already exists. We have a father and son. There's going to be a natural inheritance issue there anyhow. We have the donee.
Temporary passing of property.
Yes. We have the donee already in possession of the property to be transferred that could actually only be returned to him by giving the keys back to the father. Of course, if the father has passed, it is not possible to give those back. There was some debate as to whether the car was given before, but I do believe the judge accepted that it was given and taken back. So what he said is you'd made no such gift because you had taken back dominion of the car or ownership of the car.
What was missing was the intention, surely. The intention to transfer ownership. It was clear that
yes,
possession cannot be ownership, isn't it? The thrust of Woodard, you know, father and son, car being loaned, you know, habitually. But it doesn't in itself, you know, half a swallow doesn't make a summer house, is the point of Woodard, isn't it?
Yes, it was argued by the appellant in the case that the father had not given the donee the logbook, insurance documents or anything like that whatsoever. and the Lord judges referred back to other cases and actually referred to the indicia title of land and working out what would be considered to be transfer of dominion. I believe it was established that given that the car could only be returned if the father survived, that there was suggestion that he was given it before and it was taken back. It would be a requirement of the DMC.
Okay.
It was satisfied that a successful judicial works causa had been established.
Okay. I understood it was in the nature of a conditional gift in the sense that it was implicitly understood in the event of death, and unlike our present appeal cases, this was almost unexpected as a bolt out of the blue, the death.
Yes.
I think
Well, again, it's another
the Lord has already made a point about that.
It's another stark contrast. The donor in Woodard and Woodard was in
Yeah.
hospital dying of leukemia.
Yeah.
He knew his time was due to come to an end. The donor in the instant case had a virus. And I'm not going to go so far as to say that she was completely oblivious to death, but I look forward to the respondents establishing the fact that proves without doubt that she was in contemplation of death. But even if she were, even if somehow she did establish in her mind that she was going to die soon, she did not mention that the property would come back to her should she live. So therefore, there is no
Which is a
judicial
point,
response.
of course, we have to take on board. If anything, Woodard drives a coach and horses through the idea that all three elements of the DMC must be present. There can be exceptional circumstances where you can rely on two, and then equity does the rest. But obviously, I take all the points you've made.
Thank you, my lord.
Thank you.
Thank you, Smith.
Thank you.